Good afternoon, everybody. We've just opened the link, so we're just waiting for a few minutes to allow everybody to join. Good afternoon, everybody. We're just waiting for a few minutes to allow everybody to join the link before we start.
Well, good afternoon, everybody, and thank you for joining me for this webinar on rectification, with a particular focus on a case I've recently been involved in, Graham and Lynch, which presented a number of challenges. This webinar is being recorded. Do please ask me questions. I won't promise that I'll be able to answer them, but do feel free to do that. Or if you think of anything later, by all means, feel free to email me with any questions that you might have. But as it is being recorded, if you don't want to identify yourself when answering a question, then of course, feel free not to do so. So, first slide, Joe, please. Rectification is a difficult area of law. There are conceptual difficulties, and some of the authorities are very difficult to discern in respect of their principles. Many of the cases go uncontested. Usually, the most interested party in contesting them is HMRC. And they are reluctant to join in too many cases. And often the decisions they make as to which cases to join can be hard to fathom. There are some cases where it seems obvious they ought to, and Graham and Lynch was one of those, and other cases where it seems they have little interest in resisting, where they decide that they are going to join. So what were the issues that Graham and Lynch particularly threw up? Well, the first was a question of jurisdiction, because what we were trying to do, as I will come on to explain, is to rectify some trusts that were established in the British Virgin Islands and not English trusts. So that was the first of the challenges it presented. Secondly, there were significant evidential challenges in respect of establishing intention for the purposes of rectification. And then finally, there was a question as to whether there truly was an issue between the parties, because by the time that we made this claim for rectification, the assets of the trust had all been appointed out to the respective beneficiaries. Next slide, Joe, please. So to provide you with some of the factual background, and I think you will appreciate that I might be suffering from a degree of cabin fever by now, because there are at least a couple of nice photographs of offshore locations. Alan and Angela, Alan was my client, Angela was his wife, were domiciled at the relevant time when the trust was set up in Monaco, where they had been for some years. However, their sons wanted to establish themselves in England, and they wanted to buy properties for their sons to occupy in England, but they wanted to do so in a tax-efficient way. And they were advised to set up trusts in the BVI, and it was impressed upon them that it was vitally important that they were excluded from any benefit under the trusts. And Alan and Angela were not included in the class of beneficiaries, but, and this is important, they were not excluded from benefits specifically, and there was a wide power in the trust to add beneficiaries of all kinds. Next slide, Joe, please. So what was the tax problem that the private client lawyer acting for Alan was alerted to in relation to this matter? Well, the structure that had been set up involved a trust set up in the British Virgin Islands by a non-dom, but it was clear that Allen was the economic settlor of a trust called the Broadhaven Trust. There were then other trusts set up by a non-dom associate of the solicitors, the Mr. Lynch in the title of the case, and he arranged for a trust to be set up for each of the properties that were purchased for the Graham sons. And the way in which matters were structured was that there was an interest-free loan made by Broadhaven to each of the 4 trusts, who then purchased the property in England. And the risk, and I put it no higher than this was a risk, was that HMRC would argue that the interest-free loan was in fact a gift by Allen to the 4 trusts. HMRC take the view that the grant of an interest-free loan is in fact a gift of the interest, although their reasoning is probably open to some debate. And of course, HMRC would have argued that as the economic settler of the Broadhaven Trust, Allen was, by way of associated operations, making a gift to the 4 trusts. Finally, as he was not specifically excluded from benefit and could be added as a beneficiary, there was an argument, and again I put it no higher than that he could be regarded as reserving a benefit under the 4 trusts. Now, by the time that Allen was being advised in respect of these matters, he very sadly had lost capacity, but there was real concern that when he died, HMRC would raise the gift with reservation argument, and this would lead to litigation for the family, who had never anticipated that this was a problem. Next slide, please, Jo. So just to recap on some of the basic principles of rectification. The first point is that the remedy is discretionary. It's an equitable remedy, and the court can refuse to order rectification if, for example, there has been delay which has caused prejudice. Having said that, my experience is that if there is a good case for rectification, then the courts are not going to refuse the remedy. The second point, and it's an important point, is that the court does not rectify arrangements, but rectifies the instruments reflecting them. And this is vitally important when going on to consider questions of consequences and effect. It is the instrument which reflects the arrangement that the parties intended to enter into that the court can rectify to reflect the true intention of the parties. And the final point, and it was vitally important in this case, is that the court will rectify an instrument, notwithstanding that the purpose of that rectification is a tax advantage. And there's some misapprehension about this, but it is quite clear that rectifying in order to avoid a tax charge is perfectly legitimate, and the courts will not refuse on that basis. And indeed, it's probably fair to say that certainly as far as unilateral documents are concerned, such as settlements and deeds of variation, most rectification applications are for the purposes of saving tax. And that is why it is the practice to ask HMRC if they would like to be joined as parties and to provide them with draft proceedings so that they can decide whether it is a matter they wish to join. Next slide, please, Jo. The second part of the principles is that the evidence in support of the claim must be, and I lift this quote from a fairly old case, strong, irrefragable evidence. Now, I'm not going to warrant that I've pronounced that correctly. It's one of those quotes that one avoids when in court because few people actually know how to pronounce it. But what it really means is that the evidence has to be indisputable. Of course, a rectification claim, like any other civil claim, is brought on a balance of probabilities. But the point of this is that there has to be not just some evidence that the parties intended something different, but strong evidence that it's going to be difficult for a party to dispute. As I've already mentioned, the court has power to rectify voluntary transactions, and in those circumstances the court is only looking at the intention of the person entering into the transaction. So, for example, the set law of a trust or the person making the gift under a deed of variation. There are very complex factors that the court has to take into account when looking at transactions which are not unilateral, where there is an agreement, such as whether or not the intention crossed the line. But those issues fortunately don't apply when the court is rectifying voluntary transactions. And then finally, there is the effect consequences issue. Now, this is something which has caused an enormous amount of difficulty, not just for the law of rectification, but also for the law of mistake before the Supreme Court got their hands on the matter in Pitt and Holt. Essentially, the mistake has to be the right sort of mistake. It has to be as to the effect of the transaction. In other words, the parties have to intend, for example, to enter into a settlement which excludes the set law. It is not enough for them to intend to enter into a settlement not thinking about whether the set law should be excluded or not, but only later discovering that in fact it has unfortunate tax consequences. So that is really the distinction. In some cases it can be a very difficult distinction to apply, but essentially what you are looking at is what did the parties intend by this transaction. And I'm going to come back to this point because it's something that does cause difficulties in practice. Next slide, please, Jo. So the first issue that confronted us in the Graham and Lynch case was the question of jurisdiction, because the trusts were established in the British Virgin Islands. And as much as the legal teams felt that a trip to the British Virgin Islands would be an attractive proposition, that was going to be expensive. And bearing in mind that HMRC were going to be asked whether they wanted to join or not, it seemed far more sensible to have the litigation in England and Wales if it could be achieved. So we asked the offshore trustees to submit to the jurisdiction of the English court because there's authority in the case of Ewing and Ewing to the effect that the jurisdiction of the English courts over offshore trustees is an in personam jurisdiction. So provided you have the trustees within the jurisdiction or submitting to the jurisdiction, then the English court can make a ruling. And so the offshore trustees agreed to submit to the jurisdiction of the English court and appointed English solicitors to act for them. They took no further role in the matter other than acknowledging service and saying that they didn't intend to defend the application. It's important to note, however, that the law that was applicable was not English law, but BVI law. Fortunately, as far as rectification is concerned, in this type of case, the law is based on English law in the BVI. And indeed, of course, there is the very useful presumption in English law that if there's no expert evidence to suggest that the law is otherwise, then there is a presumption that it will be the same as English law. And the court accepted in Graham and Lynch that it had jurisdiction both to rectify those British Virgin Island trusts and applied BVI law on the basis that it reflected the same principles as English law. Next slide, please, Jo. So now we come on to the strong irrefragable evidence that was required, and this presented a particular challenge in this case. Alan had lost capacity and he wasn't in a position to give evidence, and the solicitor who had drawn up the trusts had ended his career in disgrace. He had stolen funds from another Graham family trust and had been struck off, and so no assistance could be expected from him. And this is why the case is somewhat unusual, because usually the first port of call in any rectification claim is going to be the draftsman of the instrument which contains the mistake. However, what we did have was evidence from Alan's wife Angela and also from his sons. Unfortunately, Angela had been very involved in the setting up of the trusts, and she was able to give evidence that it was impressed upon them that not only were they to be excluded from benefit under the trusts which held the properties, but they also had to derive no benefit from any actual use of the properties. And they were absolutely scrupulous about this. Two of the properties were in London, and they made it very clear that when they stayed in London, they did not go to the properties or stay at the properties. They stayed either at the Royal Thames Yacht Club or at a hotel, and they were able even to produce the receipts of that. There were, unfortunately, no contemporaneous attendance notes when the trusts were set up, but there were some subsequent attendance notes and also trust reviews undertaken by the firm that had originally set up the trusts. And they were very helpful because all of them recorded that Alan and his wife Angela were to be excluded from benefiting under the trusts. And although it is of course vitally important to be able to prove what the intention was at the time that the trusts were set up, nevertheless, subsequent events can provide evidence to corroborate what was intended. So while we had some nervousness, it's probably fair to say, about the type of evidence that could be adduced, it was fortunate that it did all point in one direction. And so we hoped that the court would be prepared to accept it. Next slide, please, Jo. So The next question was whether this was the right type of mistake. And as I've already said, the court will only rectify a mistake as to the effect and not the consequences of a transaction. And in particular, a case which illustrates this beautifully is the case of Allnut and Wilding, where the parties intended to set up a discretionary trust. What they had made a mistake about, and what the advisors have made a mistake about, was the tax consequences of setting up a discretionary trust, which led to an immediately chargeable transfer for inheritance tax purposes. So there was a mistake as to the tax consequences, but at the end of the day, the parties still intended to set up that discretionary trust, and their attempts to persuade the court, both at first instance and then rather remarkably in front of the Court of Appeal, that what they really intended was to set up an accumulation and maintenance settlement, understandably failed. In this case, it was clear that the parties had intended that Alan should be excluded from benefit, and indeed everybody was all too aware of the tax consequences of not doing so. So it really was a mistake as to effect. Joe, next slide, please. The most difficult aspect of the Graham case was there really an issue between the parties? And that arose because by the time that I was asked to advise on the matter, all the assets of the trusts had been appointed out. There was nothing there. And there's some case law which says that the court will not act in a case where to do so, to rectify, would not change the rights of the parties involved. There is a difficult case called Whiteside and Whiteside, and it involved a maintenance agreement entered into by a husband to maintain his estranged wife. And it was drafted in such a way that it was not tax effective for income tax. And this was in the days of super tax, and so that really mattered. But the parties had already agreed that they would change the agreement so that it was effective. And the application to the court was simply to rectify, to have retrospective effect. The case is difficult because the reasoning is not very clear, but also there are other reasons why it seems that the court refused rectification. In particular because the husband's solicitor who drafted the deed had insisted on drafting it in the way that had caused the problem. Now, this case was explained in the first instance decision in Rackall Group Services and Ashmore, which did go to the Court of Appeal, but one really wants to look at the first instance decision of Peter Gibson. And in that case, it was made clear that there's no need for there to be a dispute between the parties. And of course, there usually isn't in a rectification claim. All the parties want the same thing. But there had to be some change to the rights of the parties involved. So the rectification had to create some change to the rights of parties, which it was said in the Whiteside and Whiteside case hadn't really been the case. Next slide, please, Joe. Before Graham and Lynch came to court, there was a very helpful decision of Mr. Justice Barling in a case called Giles and the Royal National Institute for the Blind, which involved the rectification of a deed of variation. Two sisters had left wills in very similar terms to each other and then to charities. And the same charities were going to benefit, but a deed of variation had been drafted improperly. And rectification was sought because it would reduce the inheritance tax that was payable. And the court was there rightly concerned with the fact as to whether there was an issue between the parties. The same four charities were going to benefit, come what may, and the only question is how much they would get, depending on the deed of variation and how it was drafted. And the court held that the fact that the charities would get less if inheritance tax was payable did mean that there was an issue between the parties. The court also interestingly held that there was an issue because if rectification was refused, it would have an impact on the negligence claim that was being brought against the draftsman. Next slide, please, Jo. So what was the issue in Graham, bearing in mind that the trusts the funds had all been appointed out? Well, I ran two arguments in relation to that. The first was that unlike a corporation or an individual, a trust doesn't die. Just because you appoint out the funds doesn't mean that the trust doesn't have some existence. So for example, if there was a creditor of the trustees would still have a lien over the funds that have been appointed out. That was the first argument that found favour with the court, that the trusts might have a future existence, and by rectifying them to exclude Alan and Angela from benefit, that did of course affect who the class of beneficiaries was going forward. And I use the example of some assets coming into the trust which had not been expected and required to be distributed out. And there was no possibility of Alan and Angela being added to benefit from those assets. I also argued, by analogy with Giles, that there would be an argument with HMRC about give with reservation if the trusts were not rectified. Now this might look very close to an argument that we were rectifying purely for tax purposes, and indeed it was. But I wonder if Whiteside and Whiteside were really seriously challenged, for example, in the Court of Appeal, whether it would carry on in existence. So our argument was that if the trusts were rectified, there was really going to be nothing for HMRC to argue about. And Master K, who heard the application, followed the Giles case. And of course, it's interesting, before the Chancery Modernisation Review, this would have been a matter heard by a High Court judge, but many more of these applications are now being dealt with by the Chancery Masters, and extremely well as well. Next slide, please, Jo. So what are the takeaways in relation to this case? Well, first of all, it struck me that it is worth thinking of inventive ways to avoid litigating offshore, which can often be extremely expensive, and sometimes parties will simply not litigate. Don't be daunted by the absence of evidence from the draftsman. Of course, it's always going to be the first port of call, but if it's not there, it doesn't mean that the court won't order rectification if evidence can be garnered from other sources. Give some serious thought as to whether or not there is an issue between the parties, and also as to the effect and consequences point. Is this an application which is designed to simply do a better, enter into a better arrangement than the parties ever thought about? If so, then the court is not going to rectify. Is there an issue between the parties? But the good news with Giles and also with the Graham case is that the courts do seem to be rowing back from the issue point. Now, that's all I wanted to say, but I have got a question which from my colleague Ruth Hughes. Thank you, Ruth. Was there any indication that there was actually a creditor of the trust, or did we rely on the trustees' lien for any tax liability? And the answer was there was, in fact, no indication that there were any real creditors of the trust. And the tax liability would not, the tax liability we were worried about was not a tax liability that the trustees would have faced, but was a liability for Alan's estate. But my point was that you never know. For example, there might have been funds coming in from the sale of the property into the trust that weren't anticipated, or even possibly damages for any sort of claim as a result of the sale of the property. It was hypothetical, but I think that's quite important. Another, again, very good question from Rafiq Sham, asking me to elaborate on the effect and consequences and the demarcation line seeming to be very thin. The way I like to think about it is you have to go back and look at what the parties intended to do. What did they intend to do? Did they intend, as they did here, to exclude Alan and Angela from benefit? If they did, then the mistake they make is in recording that in the trust. So when the trust was executed, it didn't exclude them from benefit. It left the possibility they could be added as beneficiaries. So that's the sort of line one's looking at. What was intended? There are cases where what was intended can be perhaps rather vague, and it can be quite difficult in those circumstances to distinguish between the tax consequences that ensue and what was intended in the first place. But it's always worth, it seems to me, to go back and look at what the parties were intending to do in the first place. Well, I think that's the end of any questions that I've got now. But if anybody thinks of anything, I'd be more than happy to deal with those questions on email. Thank you very much for being such an attentive audience. Goodbye.